the Fifth Circuit on last Monday issued Rodriguez v. Garland, and I'm not usually here championing the Fifth Circuit decisions. They're not usually the most non-citizen friendly, but Rodriguez v. Garland, as I read it,
Mm-hmm.
and that could be wrong. I've gotten in trouble before, but
Is that the post you did on Instagram where you like, is this interpretation like
it
that?
is what I did on Instagram and Twitter. I don't usually go to it, but it seems like the Fifth Circuit said on Monday that an in absentia motion to reopen must be granted based on a deficient notice to appear within the meaning of Nis Chavez and Pereira that doesn't have the date and time of the first removal hearing. It must be reopened, regardless of whether, it would seem, the non-citizen received the notice of hearing. And maybe that's a bit far, but certainly regardless of whether the non-citizen can overcome the presumption of delivery of the notice of hearing. That's usually the big problem with motions to reopen. There's a presumption that when EOIR sends the notice of hearing, it got to where it's supposed to go. The Fifth Circuit did not care about that in Rodriguez v. Garland. It expressly said, we don't need to address this because the deficient NTA was sufficient, and they remanded it back to the board. And that is because the in absentia motion to reopen statute under the Act.
Sorry for those here on audio, we're getting comments and stuff I'm posting on the videos. It's distracting a little bit.
I know, I can read them too. I know, and I appreciate it, but and again, for the Facebook users, we can never see the identity of the user, but it seems, and that's because the statute, the motion to reopen statute, expressly references INA Section 239A. It says you need to get notice within the meaning of INA Section 239A. And that's the same statute that lists what needs to be in a notice to appear. And that's the same statute that the Supreme Court was talking about and reviewing in Nis Chavez. And so the Fifth Circuit is saying Nis Chavez addressed this. We don't care that it was in the cancellation of removal context. It applies to no notice motions to reopen. That doesn't necessarily, to me, mean that you have to dismiss removal proceedings based on a deficient NTA, because I'm not aware of a statute that initiates proceedings based on a compliant 239A notice to appear. So you're in this weird situation, again, to me, where you don't necessarily dismiss proceedings based on a deficient NTA, but if you don't show up, you have to get it reopened.
Yeah.
I don't know, that does seem crazy. We'll see what happens. And I'm certainly not advocating for not showing up. Yeah. But what a case in Rodriguez v. Garland. And, I think most in absentia motions to reopens happen in the Fifth Circuit, right? I mean, that's Texas, at least. If not the Fifth, then the Ninth. But either way, that's a big deal.